Next story we have for us is California bill makes app-based companies treat workers as employees. We'll just read a little bit of the article and then we're actually going to read the bill. California legislatures approved a landmark bill on Tuesday, which requires companies like Uber and Lyft to treat contract workers as employees, a move that could reshape the gig economy and adds fuel to a year-long debate over whether the nature of work has become too insecure. The bill passed 29-11 in the state Senate and will apply to app-based companies despite their efforts to negotiate an exemption. On Wednesday morning, the Assembly gave its final approval, 56-15. California Governor Gavin Newsom endorsed the bill and is expected to sign it. Under the measure, which will go into effect January 1st, workers must be designated as employees instead of contractors if the company exerts control over how they perform their tasks or if their work is part of a company's regular business. So that's a pretty big change. One would imagine that that would sweep in Uber and Lyft and Postmates and all the other businesses. So let's read the bill and see what it says and see what we can learn from the text of the legislation. So let's start with the Legislative Council's digest. So the Legislative Council is an attorney that works for the legislature, and they're preparing a summary of the bill. So this is not part of the law, but it is the Legislative Council's summary of the law. So we can read that to get a good gist of what we're talking about. Assembly Bill 5 as amended, worker status, employees and independent contractors. Existing law as established in the case of Dynamics Operations West Incorporated versus Superior Court of Los Angeles in the Fourth Circuit of California creates a presumption that a worker who performs services for a hirer is an employee for the purposes of claims for wages and benefits arising under wage orders issued by the Industrial Welfare Commission. Existing law requires a three-part test, commonly known as the ABC test, to establish that a worker is an independent contractor for those purposes. So there's a presumption that you are an employee and you have to prove you're a contractor. Fine. And that's how the law was. Existing law for the purposes of unemployment insurance provisions requires employers to make contributions with respect to unemployment insurance and disability insurance for wages paid to their employees. Existing law defines employee for these purposes to include, among other individuals, any individual who, under usual common law rules applicable in determining employer-employee relationships, has the status of employee. So in the United States, all employers pay unemployment insurance to help fund unemployment costs. So the employers help to fund some of that. This bill would state the intent of the legislature to codify the decision in the Dynamics case and clarify its application. The bill would provide that for the purposes of the provision of the Labor Code, the Unemployment Insurance Code, and the wage orders of the Industrial Welfare Commission, a purpose providing labor or other services for remuneration, in other words, pay, shall be considered an employee rather than an independent contractor unless the hiring entity demonstrates that person is free from control and direction of the hiring entity in connection with the performance of work. The person performed that work that's outside the usual course of the hiring entity's business, and the person is customarily engaged in an independent established trade, occupation, or business. So when I'm reading that kind of language, the kind of thing I'm thinking about is a business who, let's say it's Uber, okay, and they have an office. I'm sure they do, and they have offices. And they need someone to come in and do plumbing work for them. They need someone to come in and do janitorial work for them. One of their windows bust. They need someone to repair a window. They have a leak. They need a plumber. They need to repair something, so they hire a general contractor. So those would be the kind of people that would not be in line with Uber's business. Uber is not in the business of doing those things. So those are people outside that. Those are people customarily engaged in independent trades and occupations. So I think that's the kind of thing they're reaching for. The bill, notwithstanding this provision, would provide that any statutorily exempt employee, any statutory exemption from employment status, or any extension of employer status or liability remains in effect, and that if court rules the three-part test cannot be applied, the determination of employee or independent contractor status shall be governed by the test adopted in a different case. This bill would exempt specified occupations from this application of law, and would instead provide that those occupations are governed by a different application of law. These exempt occupations would include, among others, licensed insurance agents, certain licensed healthcare professionals, registered security brokers or investment advisors, direct sale persons, real estate licensees, Commercial fishermen, workers providing for licensed barber or cosmetology services, and others performing work under a contract for professional services with another business entity or pursuant to subcontraction in the construction entity. So we give a list of some businesses that we exempt from these rules because we want to treat them differently. And as we read in the article, Uber was looking for an exemption and didn't get it. The bill would also require the Employment Development Department before 2021 and each March 1st thereafter to issue an annual report on the use of unemployment insurance in the commercial fishing industry. This bill would make an exemption for commercial fishermen applicable only to 2023 and the exemption for licensed manicurists applicable only till 2022. The bill would authorize action for injunctive relief to prevent employee misclassification to be brought by the Attorney General and specified local prosecution agencies. So even the fishermen and the barbers are going to fall within the scope of this pretty soon. The bill would also redefine the definition of employee described above for the purposes of unemployment insurance provisions to include an individual providing labor or services for remuneration who has the status of employee rather than independent contractor, unless the hiring entity decides that the individual meets all the specified conditions, including the individual performs work that's outside the usual course of the entity's business. So again, we're looking into what is your business and what are you hiring them to do and looking to the disjoint. This bill would state the addition of a proviso to the Labor Code does not constitute a change in, but is declaratory of, existing law with regards to violations of Labor Code relating to wage orders. This bill would also state that specified Labor Code provisions apply retroactively to existing claims and actions to maintain the maximum extent permitted by law, while other provisions apply to work performed on or after January the 1st, 2020. So some provisions are retroactive and some provisions are forward-looking. And in case you're wondering, yes, you can do that because the idea of ex post facto laws only apply in criminal context. The government can't make something criminal that happened before, but they can change civil relationships to things that happened before, and that's what they're doing. Existing provisions of the Labor Code make it a crime for an employer to violate specified provisions of the law with regard to an employee. The Unemployment Insurance Code also makes it a crime to violate specified provisions of law with regards to benefits and payments. By expanding the definition of an employee for purposes of the provision, the bill would expand the definition of a crime, thereby imposing a state-mandated local program. The California Constitution requires the state to reimburse local agencies and school districts for certain costs mandated by the state. Statutory provisions establish procedures for making that reimbursement. This bill would provide that no reimbursement is required by the Act for a specified reason. So there's a general rule that says we have to pay you, but they're going to change that generalized rule. Fair, fine enough. So I think we got some of the stuff, but let's look at some of the stuff that's changed, and we can tell it's changed because they faithfully color-coded it. So we got a declaration of stuff. So these are all like preambles. These aren't really law as such as part of the law, but these are like more forward-looking intent statements, if you like. Okay. So they say a person or organization who's licensed by a Department of Interior shall not apply to this. And they talk about psychologists, veterinarians, and nothing in this subsection shall apply to employment status currently or potentially governed by the collective bargaining agreements. Fair enough. Nothing in this subdivision prohibits an individual from choosing to perform services at the location of the hiring entity. If the individual is performing services at the location of the hiring entity, then the individual issues Form 1099 to the salon or business owner from which they rent space. 1099 would be typical for an independent contractor. That's what you typically do. W-2 is for an employee and 1099 is for an independent contractor. So that's very true. And so then we have some tests for whether a business entity is independent or not. So we look at providing own tools, vehicles, and equipment consistent with the nature of work, and so forth and so on. They talk about tutors. They define that separately. They talk about motor club services. And they give an injunction for relief due to misclassification. So fine. And that is about it. Okay. So that is the text of this bill. Now, what's really interesting is the way that this is written would apply to all businesses for all services. Now, Another person, another YouTuber, Hoag's Law, did a video on how this would impact gaming, because he thinks, and it's probably fair, that a lot of game companies, and of course there are a lot of them based in California, would hire people on an independent contractor basis, and that's no longer possible. I'd also see that this would seem to impact the movie industry. They can't hire people as independent contractors. Now, I don't know how relevant that is to the movie industry. The actors are, being brought in, but this could be read on that too. So I think this impacts the media organizations. This impacts gaming, impacts a lot of other things. So I think it's a pretty big shift in the law. But the California legislature gets to define that if they want. Um, and Deirdre pointed out very correctly, the movie industry won't be affected as they are collectively bargained. That is a very, very fair point. And so maybe that is exactly why they put in that language about collective bargaining, because Screen Actors Guild, they're unionized, so they have collective bargaining. So maybe this exempts movies and so forth and so on. So that's a very, very fair point. So it would also be interesting to see if some companies attempt to create collective bargaining agreements where none exist as a way to get around this law. So maybe some of these gaming industries and others will want to have unions as a way to deflect some of this. So I don't know if they'll go down that route, but that's part of a possibility. Um, Someone asked if someone's not part of the union. Well, I guess if someone's not part of the union, they're not impacted by the collective bargaining agreement. So yeah. And someone pointed out you can't work for a lot of places unless you're part of the Screen Acting Guild. Yeah, that's of course a private deal. That's not law. But there are a lot of studios that will only hire union people and union shops, and there are a lot of people who won't. So there are a lot of people who are independent. And I've done a little bit of acting, on fun, and someone pointed out that if you're being offered your union card, you might want to not get it right away because it limits the number of gigs that you can get. So it can be, something that restricts you more than enables you, if you're a brand new actor. So for what it's worth, those of you who are trying to get your SAG card, if someone offers it to you, you might want to hold back. So there you go. So we'll see how this law gets impacted and what it impacts in California and how it affects, Uber, Lyft, Dashbates, Uber Eats, how it affects TaskRabbit, how it affects a lot of businesses that are doing this in gig economy.